Welcome to Disability Law for Railroad Workers.
Hey everybody, welcome into an all-new episode of Disability Law for Railroad Workers with Burnett Driscoll Attorneys. I am your host, Mike Leon. Joining us again today is Derrick A. Pearce, a seasoned litigator with more than 30 years of experience handling these insurance disputes and disability claims under the Employee Retirement Income Security Act, or better known as ERISA. In today's episode, we're looking beyond the initial claim to focus on what happens after a disability denial. Derrick's going to explain how ERISA appeal process works, why the deadlines are so strict, and what it takes to build a winning case, in federal court. So Derrick, it's good to see you as always. So when someone's ERISA disability claim is denied, what is the very, very, very first thing they should know about their rights and the timeline for this appeal process?
Thanks, Mike. I appreciate you having me on again. The very first thing you should know about appealing a denial is when the appeal is due. If you miss the due date, you may lose your right to challenge that decision. And ERISA requires that these denials be in writing, explain the specific reason for the denial, and tell you how long you have to submit an appeal. In most cases, that's 180 days, but the denial letter will be specific about how long you have to submit that appeal.
So let's get into that. You just said 180 days to file it, but what happens if the deadline is missed?
Well, as I mentioned, most plans allow 180 days to submit an appeal, but again, you should go by the date in the denial letter. The appeal deadline is extremely strict one. There are some rules that you can kind of get away with not complying with perfectly, but the appeal deadline is a extremely strict one. If you miss that appeal deadline, courts later will generally not excuse that, and your right to further contest the denial in court will be lost forever. You're basically just done. That's why it's really important to immediately calendar the appeal due date as soon as you get that denial letter.
Derrick, let me ask you, the ERISA requires claimants to exhaust all administrative remedies before they even go to court. What does that actually mean, though, in practice?
What that means is that you must fully and completely follow all of the steps described in the disability plan for contesting decisions before you can go to court. Disability plans have written procedures for disputing claim decisions. Most plans describe an appeal process, and that appeal process is often described in the denial letter, like the one we've been talking about today, that you have to follow before you can file a civil lawsuit. Some plans do require you to go through a second level appeal process if your first appeal is denied. But the bottom line is that you have to check all of those boxes, all of those rules that you have to follow, those steps that you have to complete before you go to court. If you miss a box, you can't go to court.
Derrick, what kind of evidence should someone include in their administrative appeal to help strengthen their case?
Well, the very best evidence to include in an appeal are focused medical opinions about your functional limitations. It's not enough to rely on a diagnosis alone. Direct medical opinions from a doctor about any limitations that you have, and for example, sitting, standing, lifting, carrying, reaching, or grasping, those are all extremely helpful. You got to remember that the insurance company is looking at the physical demands of your job and trying to determine whether you have any functional limitations that would prevent you from performing your job duties. Any opinions that you can get from a doctor, from your own doctor, from a physical therapist, or by undergoing a functional capacity exam, those will go a long way to help you in preparing your appeal and improve your chances significantly if you can get those opinions from a doctor.
And Derrick, explain to folks out there why it could be risky to wait until the federal court stage to gather all this new evidence or all these medical opinions. Is it risky to wait?
Yeah, waiting to gather new evidence or opinions until the lawsuit stage is extremely risky because, as I mentioned, the judge usually cannot consider new evidence. The judge has to decide the case based solely on the administrative record, which consists of your claim file, everything that was in front of the insurance company at the time that it made its final decision. And if it's not in the claim file or the administrative record, it usually can't be considered in court. So if you wait until litigation to gather new evidence or medical opinions, it's usually simply too late.
Derek, in a previous episode, we talked about if people go it alone without an attorney, and the steps there. What are some mistakes people do make when they do handle this ERISA case and the appeal on their own without an attorney?
Well, many insurance companies will try to trick you into submitting an insufficient appeal. Oftentimes, insurance companies will send you a one-page form along with the denial letter and explain all you have to do to appeal our decision is complete and return this form. Well, it's not a very good idea because good appeals are tens of pages in length and include hundreds of pages of exhibits and medical records, and a one-page form simply is not sufficient for that. And once you submit an appeal, you're done. Once the evidence is closed, you only get one bite at the apple. You usually have 6 months to gather evidence and formulate arguments, and you should take advantage of that time and not just simply fill out a one-page form that the insurance company asks you to complete. Another mistake I see in do-it-yourself appeals is failing to remember that what the standard is that the insurance company is applying. If the test for disability is whether you are physically able to perform the material duties of your job, your appeal must describe those job duties very specifically and contain medical evidence explaining why your condition prevents you from performing those duties. It's not enough to say that you have a certain condition or a certain diagnosis. You really have to explain how and why that condition causes specific functional limitations.
Derek, in a previous episode, you explained a little bit the process of once these go into court, how it differs from a typical jury trial. Can you explain that process a little bit more in depth?
Sure. If you've exhausted all of your administrative remedies, your appeal's been denied, and you find yourself in federal court in an ERISA case, it's going to look a lot different than what you may think of as a normal lawsuit. Typical jury trials take place after months and months of discovery, like depositions, subpoenas, and other pretrial activities. In ERISA cases, the process is severely shortened and stripped down. Ordinarily, there's no discovery permitted. No witnesses may be called, no expert witnesses may be called, and most of the time there really isn't a trial at all. Instead, the judge reviews the administrative record and written submissions by each side and simply makes a decision based on a cold record without any hearing at all.
And I want to get into the judges and how they evaluate these cases. Are they looking at medical facts, fairness, whether the insurer followed rules? Like, what is it that the judges are looking for when they evaluate these cases?
Well, how a judge evaluates the case depends on language that's in the disability plan. If the plan grants what's called discretionary authority to the administrator to make certain decisions, and most of these plans do that, the judge has to review the case under a very deferential standard, which means that the judge cannot substitute his or her own judgment for the decision that the insurance company made, as long as there is some evidence or substantial evidence to support the insurance company's decision. So what that means is that a judge may review the administrative record and disagree with the denial, but if the insurance company followed procedures and timelines, and there is at least some evidence to support the decision, most of the time the judge just has to let that decision stand and the claimant loses. So for this reason, winning ERISA cases is a real uphill battle, and it's an unfair battle, but it can be done.
So, Derek, as we land the plane on this episode, what's your best advice out there? Someone who's listening, they've received an ERISA denial letter. They don't know what to do next. What's a piece of advice you would give to them?
Well, it never hurts to consult with an attorney. Even if you don't end up retaining one, most ERISA attorneys are happy to speak with you and answer general questions about the procedure and what to expect. Short of that, I would recommend that if you receive a denial letter, immediately calendar that appeal deadline, immediately request a copy of your claim file from the insurance company, and begin building sort of a surgical appeal with targeted medical opinions, objective testing where you can get it, and point-by-point rebuttals of the insurance company's reasons for the denial. Treat the appeal like it is your last best chance to win.
Derek, thank you for the time and insights as always. Truly appreciate it.
Thank you.
And thank you to everybody out there listening to this episode of Disability Law for Railroad Workers. Special thanks again to Derek for hopping on with us. If your employer-provided disability benefits have been denied, you're unsure what to do next, do me a favor, visit BurnettDriscoll.com today to learn more about your rights under ERISA. And to connect with Derrick and the team, don't forget to like, subscribe, leave a review, and comment, or share this episode with someone who needs to hear it. As always, I'm Mike Leon. We will see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.